Tonight on Dr. Phil Primetime. Do Lyle and Eric Menendez have a shot at freedom?
Your recommendation to the court would be to not grant a new hearing.
It's inconceivable that if the letter actually existed circa 1988, that they wouldn't have introduced its contents to further corroborate the sexual abuse testimony.
On the petition for clemency, if the governor of California granted that, they could be released immediately.
Done. No hearing, no appeal, just you're done.
Tonight, I'm diving into a dark chapter of American crime history that shook Beverly Hills and the country with the help of former Los Angeles prosecutor and Merit TV's own Loni Coombs. But first, the Menendez family had it all: wealth, status, and a mansion in one of the most exclusive neighborhoods in the entire country. But on August 20, 1989, their picture-perfect facade came crashing down in a hail of gunfire. Jose and Kitty Menendez were relaxing in their den watching TV on what seemed like an ordinary Sunday evening. Little did they know their own sons, Lyle and Eric, aged 21 and 18, were about to unleash a brutal attack that would forever change the course of this family. The crime scene was nothing short of horrific. Jose was shot point blank in the back of the head, while Kitty, in a desperate attempt to flee, was gunned down with multiple shots. The once pristine living room was now a gruesome scene of violence with over a dozen shotgun blasts, leaving a haunting mark on the walls and their victims. At 11:47 p.m., a frantic 911 call pierced the night. On the other end of the line was a hysterical Lyle Menendez, barely able to form coherent sentences through his sobs.
Beverly Hills emergency?
Yes, please.
What's the problem? What's the problem? What's the problem?
Someone killed my parents.
Pardon me? What? Who? Are they still there?
Yes.
The people... What?
No.
Were they shot?
Get away from me.
Were they shot?
Yes.
They were shot?
Yes.
102, 722 North Elmore.
What happened?
I have a hysterical person on. We're trying to get screened further. Other units responding. Is the person still there?
What happened? We have units around. What happened? Who shot who?
I don't know anything. I just came home.
You came home and found who shot?
Mom and Dad. You know if they're still in the house, the people that did the shooting.
Get away from me. Okay. Hey, let me talk to Eric. Who is the person that was shot?
My mom and my dad.
Your mom and dad?
My mom and my dad.
Okay, hold on a second. Okay, we're on our way over there with an ambulance.
Okay, I gotta go.
Little did the authorities know this call would be the beginning of a case that would captivate the nation for years to come. I sat down with the new Los Angeles District Attorney, Nathan Hochman, just after he got his new job and asked him what he thought he was going to do with the Menendez case. Is there new evidence?
The new evidence has been alleged by the defense as to a letter that there is between Eric Menendez and his cousin that was sent months before the actual shooting back in 1989. And then there was another form of evidence of another individual that was saying that they were sexually abused by the Menendez's father.
Has the letter been authenticated, that it was written by Eric?
We never received the original of the letter, and we're evaluating it.
And does the original exist? Do they know?
The original has never been produced by the defense.
I see. Speaking hypothetically now, was this information available at the time of the original trial?
Again, that is another fact that we're determining on whether or not it meets a very rigorous standard for habeas review, which would get them a new trial.
Yeah. If it was available but not presented, does that meet the habeas standard, or would they have to come with some proof that they had inadequate counsel if they didn't find it and present it?
You could always try an ineffective assistance of counsel defense, but that would follow the analysis as to whether or not the information's actually new. So the first thing you'll determine is whether or not it's new, whether or not it meets the elements, and they're pretty rigorous to get a new trial. And if that's denied, then the defense may go ahead and look at the issue as to whether or not their counsel properly presented it in the first place.
In a recent development, District Attorney Nathan Hochman has taken a firm stance against granting a new trial for the Menendez brothers and has asked the court to deny Eric and Lyle Menendez habeas corpus petition.
The Menendezes have already had their direct appeal through the California Court of Appeals and California Supreme Court, and they have lost. They've even had one level of California habeas, which they lost, and one level of federal habeas, which they've also lost. So now they've come back for a second California habeas petition. And in coming back for that, they have basically said there are two new pieces of evidence, along with their arguments, that justify them getting a new trial. Is this credible evidence? We argue in many different ways it is not credible evidence, which is why we conclude in our informal response that the court should deny the current habeas petition by the Menendez brothers.
Following his pivotal press conference, I spoke with District Attorney Nathan Hochman regarding the Menendez brothers case.
Well, D.A. Hochman, thank you so much for taking the time to talk to me.
My pleasure. Great to see you again.
Well, it's good to see you again. I listened to your press conference about the Menendez brothers, and I guess my first question is, from the standpoint of you as the DA and from a habeas standpoint, from the legal standpoint, it doesn't sound like this was a close call after you studied this case.
That's correct. The habeas petition involves whether or not the new evidence compels a new trial. So to get a new trial after you've already been through all the appellate process, I mean, this particular case went to the California Court of Appeals, the California Supreme Court, the federal U.S. District Court, the U.S. Ninth Circuit. To get a new trial at this point, you gotta jump through some very high hoops. And the new evidence that they presented, which was an undated photocopy of a letter between Eric Menendez and his cousin, supposedly December 1988, that had never seen the light of day until 2023 or 2015, wasn't a close call as far as being a timely, credible, admissible piece of evidence, nor was the Roy Rossello declaration, where he alleged that he had been sexually molested by Jose Menendez in the 1980s, because both Menendezes admitted that they didn't find out about this till the 2020s, not back when they were shotgunning their parents to death in 1989. So it couldn't have played any role whatsoever in their mental state when they engaged in these murderous actions.
Right. And one thing I want to bring out, you and I have talked about this before, but I want to be very clear. I'm not suggesting that you gave me any preview of this case or how you looked at it at all, other than you're telling me that your intention was you were going to go through thousands of pages of testimony and evidence and records before you took any position on this case whatsoever. So this wasn't a knee-jerk response by you as Los Angeles District Attorney. You really did your homework and reviewed thousands of pages of testimony, trial records, evidence, as well as the applicable law on this. So you really did your homework on this. Is that a fair statement?
Absolutely. I engaged an entire team. We went through over 50,000 pages of 2 months-long trials. We spoke to Menendez family members, everyone that wanted to speak to us, defense counsel, prior prosecutors in the case. We did our best to do our homework. We filed almost a 90-page brief today as an informal response required by the court in connection with this habeas petition. So we've done our best to dig deep into the trial record so that when we wanted to credibly say that this new evidence would not have likely affected the outcome of the trial, we could say that confidently.
And, people talk about the Menendez brothers as though this is one case. And you made a great point to me when we talked about this a few months ago, that this is not one case. They went to trial together, but there were two very different tracks here. This is not one case. These are two separate brothers, two different sets of evidence, actually two sets of charges. So these were not mirrors, and they had two different sets of evidence that had to be considered. So these were not identical charges. These were not identical sets of evidence, correct?
After Los Angeles DA Nathan Hochman announced his recommendations on the Menendez brothers case in his public press conference, I had an exclusive interview with the DA to delve deeper into his thoughts on the case. Here's more of that conversation.
Case. These are two separate brothers, and they had two different sets of evidence that had to be considered. So these were not identical charges. These were not identical sets of evidence, correct?
That's absolutely correct. In the criminal justice system, everyone is considered an individual. So even though we talk about the Menendez brothers, it's really Eric Menendez separate from Lyle Menendez. Now, in great respects, they acted in a coordinated fashion. In fact, they were charged with a conspiracy to commit this murder. But the other part that we have focused on is that it wasn't just one, but two different people that they killed. They killed Jose Menendez, which means they had to have an actual fear of imminent harm from Jose Menendez the night that they killed him in order to justify their self-defense. But they also had to have that same feeling, that same actual fear of imminent harm about Kitty Menendez that same night.
Now, this, as I understand it, their lawyer at the time did not plead that sexual abuse was a defense. That was not a constructive defense that was pled to justify the killing of these parents. Is that right?
That's absolutely right. Leslie Abrahams, she said this sexual abuse does not justify a killing, that it was an argument she wasn't making and never would. 30 years later, Eric and Lyle Menendez, new counsel in this habeas position, said there's only one critical issue. Were the boys molested by Jose Menendez? So Leslie Abrahamson understood correctly that the issue before the jury wasn't sexual abuse. It was, did they have an actual fear at the time of imminent harm? Basically, their parents were going to shoot them, that justified shooting them first, or was this a premeditated, willful, deliberate murder, which is what the jury found for both Menendez, for both victims.
And if that had been a defense at the time, then I suppose the prosecutor would have tried a very different case, because there would have been a lot of alternative explanations. They could have run away. They could have called social services. They could have asked for help. There were a whole lot of alternatives besides shotgunning them 12 times. And so a different case would have been presented if that had been offered as a defense, or if they had pled self-defense and with regard to the sexual abuse. And in fact, the evidence didn't support that. For example, the father was shot in the back of the head, which doesn't suggest he was coming at them and causing them to feel imminent danger at the time.
You're mostly right, Dr. Phil, but they did try to link the sexual abuse to self-defense. It's just it failed. But they said that they had been abused, Eric for almost 12 years, Lyle for 2 years, by the father. And then they said that Lyle apparently went to the father and said that if you continued abusing Eric, he was going to expose to the public and the police what had done. And the father basically let it be known that that would be a bad decision for Lyle. However, the problem with their defense is that there was nothing that had happened that night that showed that there was an imminent threat that night that the parents were going to kill them. In fact, so much so that the parents were in the den watching TV. The boys ran to their rooms, grabbed their shotguns, loaded them, shot their parents, killed dad immediately, didn't kill mom, ran back to their car, reloaded the shotgun, and then Lyle put the shotgun against their mom's face and pulled the trigger. So the jury had plenty of evidence to show, including their pre-planned alibi, they're obtaining the shotguns days before using a fake ID and address, the stories they eventually come up with, their denials to the police as to what happened, their failure to even raise a sexual abuse defense for over a year. They had all this information to show that the story about there being an actual fear of imminent harm was just that, a story, and not based on the evidence.
Well, they had 5 stories originally. Is that correct? At first, they didn't do it. It was a mafia hit. Then they were violated sexually. Lyle had been raped by someone from the outside, and then that the father had raped Eric and the mother had raped Lyle. And then Eric and Lyle had both been abused or raped by the father, and then the parents were going to kill them. That was the 5th story. Is that right? They kept rotating to a different story?
Yes, and that's exactly right. The story kept evolving over time, depending on whether or not they got caught and what they actually needed to plead in order to have a legal defense at trial. So when they realized that just saying you were sexually abused wasn't enough to justify the killing, then they had to extend the story. They had to say, not only were we sexually abused, but sure enough, our parents, and not just Jose, but Kitty as well, threatened to kill us, which is why we had to kill them first. Problem is the jury didn't believe that linkage, that they actually faced that actual fear of imminent harm, and convicted them each of first-degree murder.
Yeah. Now, does all of that go to the credibility of them now coming up with this story about the letter and not knowing about it previously? And does admissibility come into play with this being a photocopy and not an original? Does all of that play into the admissibility of this evidence at this stage of the game?
DA Hochman has recently made crucial decisions that could profoundly impact the Menendez brothers' legal status. This conversation is not just about 2 infamous brothers, but about the very nature of justice and rehabilitation in our society.
Now coming up with this story about the letter and not knowing about it previously, and this being a photocopy and not an original, does all of that play into the admissibility of this evidence at this stage of the game?
Absolutely. The habeas petition, which is the one that we dealt with today, is basically saying that we need to overturn a trial that has been affirmed by a jury, a judge, and every level of appeal that's seen it, in order, because we have new evidence that is timely, that was admissible and credible. And we go through each of those factors with each of these new pieces of evidence and say it doesn't meet the standard. So for instance, they're saying that this letter from Eric to his cousin Andy Kano was supposedly written in December of 1988. Problem is, Eric and Andy Kano both testified in both trials in 1993 and 1995. They said that the last time they had talked about sexual abuse was when Andy was 10 and Eric was 12 or 13. This would have been 6 years later. So we basically said it's inconceivable that if the letter actually existed circa 1988, that they wouldn't have introduced this letter and its contents at trial to further corroborate the sexual abuse testimony. And Eric basically says that he didn't learn about the letter till 2015, as did Lyle. The law says you cannot engage in substantial delay once you have a new piece of evidence and presenting it to the court. Moreover, he had a situation where we said that the letter is part of this continuum of fabricating stories that started days before the murder when they got the shotguns using a fake ID through their pre-planned alibi to try and make it look like Jose was a violent rapist, that they tried to get a handgun ahead of the murders because they feared for their lives, and that mom was trying to supposedly poison the whole family.
Any one of those elements could preclude this evidence from being considered by the court under this habeas petition now. Is that a fair statement?
Yes, that is a fair statement.
So at this point, with all of this being called into question, your recommendation to the court would be to not hold a hearing and to certainly not grant a new hearing based on what they're now calling new evidence.
That's exactly right. But this is the one that was designed to get them a new trial. They also have out there a clemency petition directly to California's governor, asking them to commute their sentence and release them immediately. The third track is something called resentencing. That's to actually get a new sentence, effectively go from life without the possibility of parole to life with the possibility of parole.
Do you have any evidence, any idea what the governor is likely to do with the clemency petition?
Most recently, he has said he was waiting to see what I ended up doing with the case. So hopefully he'll read my 88-page submission from today.
We are moving forward with an investigation, a risk assessment investigation that I've directed to the Board of Parole Hearings so that we can make a determination as to whether or not to move forward with the clemency request that came from Menendez's attorney.
Well, DA, I know you're very busy. A lot of people are wanting to talk to you, so I don't want to overstay my time here. So thank you so much again for granting me this time to talk about this very interesting case. I know America's been watching it closely, and I look forward to talking to you again soon. And I hope everybody in LA is hanging in there with the fires and the rehabilitation from all that. And we appreciate your leadership on that front as well. So thank you very much for taking the time to speak with me.
I very much appreciate it as well and look forward to the next opportunity.
I'm so fortunate to have you here to talk about this.
I remember the detectives talking about it. It was purposefully staged to look like a hit.
You just watched an interview I did with LA's new DA, Nathan Hochman, and how fortunate am I to have Loni Coombs, one of our lead anchors here, who was a district attorney in LA County and actually was on staff at the time that all this was happening, right?
That's right.
I'm so fortunate to have you here to talk about this, A, because you were there at the time, and B, because you were such an accomplished DA there for so long. You just heard my exclusive interview with the DA there, and I have to say, I thought he gave an excellent press conference, very well prepared, and we saw earlier that I asked him when I interviewed him several months ago, did he have a position? Could he give me any idea where he was headed on the Menendez brothers case? And all he said back then, as we all saw earlier, was these are actually two separate cases. What do you think about his approach to reviewing this case?
I have to tell you, Dr. Phil, I was so impressed and so relieved, honestly, because I had been feeling very uneasy about how the previous DA had been handling this case. And I kept wondering, where's the thorough research being done here before you just throw out your opinion here? And he took his time. He read over 50,000 pages of trial transcripts. He talked to all the prosecutors, the defense attorneys, law enforcement. He talked to any family member of the Menendez family that wanted to talk to him. He said he'd spent about 3 hours with them. So he really did a very thorough investigation and review of all this. And then when he did that press conference, Dr. Phil, I was watching it live because we were covering it live here on Merit TV, and I was just saying this is a masterclass in a closing argument. And he was literally letting the public know exactly his thought process, very transparently as to why he got to where he was. And instead of talking about what's sort of been, you know, in the TikToks and the documentary, he went back to the facts, the law, and the analysis, exactly the way a prosecutor should.
This happened in '89, so we're talking about over 30 years here that this happened. And he reminded people that what happened here is these two young men went in with shotguns and shot their parents not once, not twice, not 3 times, not 4 times, with very powerful weapons, shot them at least 12 times, including headshots.
Yeah.
So when you go in and shoot somebody over 12 times with shotguns, this is a heinous crime. And he talked about how they shot the father in the back of the head, then shot him in the kneecaps after he was dead, and then the mother was lying in the floor moaning in agony, and they shot her point blank in the face.
After reloading.
So even if you've got 2 shotguns, they had to reload. And the reason I'm making a point of that is psychologically, that gives you pause. You have to stop, wait, and then they also picked up every single shell.
Yep.
Which they then took away. So there was a lot of thought here. Look, I know that a lot of people have jumped on the bandwagon, we get that, and make up your own mind, that's fine, but let's remember what happened here.
Yeah, that's right.
They came in and shotgunned their parents
Yeah.
at least 12 times in a really brutal fashion.
And if I can just share with you, back at the time when this happened, I remember the detectives talking about it. They said that there was brain matter dripping from the walls. It was the most horrific crime scene that most of them had seen, and it was staged. It was purposefully staged to look like a hit. So they had done the research to figure out what does a hit look like, and to do that, and this is our parents that they're doing. And just think as they were going back and picking up those shell casings in the midst of what they had just done to their parents, I mean, that's the kind of mindset we're talking about here.
Yeah, and we're looking at some of the pictures from the crime scene at the time, and listen, they're really hard to look at, and we're being careful with what we show because we don't want to just get terribly gory here, but this was a gruesome crime. And when I talked to the DA, he reiterated that there were 3 different tracks that they could go down in trying to get out of prison right now, and one was a habeas petition to get a new trial based on new evidence, and then you could get a petition for clemency, which goes to the governor, and he doesn't have to really review any evidence. He can just say, I've made a value judgment that they've either been rehabilitated or have served enough time or whatever, and can just grant clemency. That's just a value judgment. And then third, a resentencing to get released or put on parole by having the court change their sentence, right? Because right now their life without parole, they could change to life with the possibility of parole, and then they can get a parole hearing and they could decide, okay, they're rehabilitated, they've done well. And you heard me ask him in the interview, you have to make a decision as DA whether you would support the habeas petition or resentencing. Was this a close call? And he said this was not a close call. What was your interpretation as a prosecutor? Did you agree that this was not a close call? Did you agree that this was not a close call?
Yes. Yes.
Why?
Okay, so he's talking about just the habeas right now, which is the motion for a new trial. A motion for a new trial is very hard to get in any case. You have to come up with new evidence that shows that if they'd had that evidence at the time of trial, it could have changed the outcome of the case. And it has to be credible new evidence. Now, they have already made these motions previous times, multiple times, to the California Supreme Court and to federal courts and been denied over and over again. And as Nathan Hochman pointed out, he said a number of these same arguments are being made now, but these 2 pieces of new evidence that he brought up, the letter that was supposedly written by Eric to Andy Cano talking about this alleged abuse by his father, and then also this new alleged witness, this person who came forward and said, I was a boy band member and Jose had also assaulted me. Now, he kind of pushed that aside very quickly because it wouldn't really be admissible in the trial because the 2 men did not know about it at the time that they shot and killed their parents, and it would have gone to state of mind evidence. So that's kind of out. But he really talked about this letter, and he really attacked the credibility of this letter, which I'm so glad because, you know, DA Gascon was asked about it. He just brushed it aside and said it doesn't really matter. But for this motion for a new trial, of course, it's extremely relevant because that is what it's based on, whether this letter is credible or not.
Well, in order for new evidence to be, it has to be timely. It has to be admissible. So it has to meet the standards of admissibility at trial, which we'll talk about in a minute. It has to be material. So this can't be some detail somewhere. It has to be material in that you would reasonably conclude that it would have an impact on the jury's decision-making process. And it has to be credible. And I got the feeling that the DA didn't feel like it met even one of those criteria, and it would have to meet them all, right? And it certainly wasn't timely.
No.
Why was it not timely?
So the first time we even learned about this letter was in 2015, years after the trials. And at that time, it came out in an interview done by Barbara Walters. Well, if they found out at that time about it, they should have presented it at that time for a motion in front of the court asking for a new trial. But they waited almost a decade later.
It was 8 years later.
Yeah, yeah.
And so the question becomes, why would they sit on this for 8 years if, in fact, it existed?
And if it was truthful, yeah, if it's real.
Yeah, and admissibility. What's the question about admissibility?
Well, it has to be truthful. Now, at the time of the trial, Eric testified in both trials about sexual abuse. Andy testified in both trials about sexual abuse. Now, they're both getting cross-examined really hard on if they're being truthful or not. If they had that letter at that time, they could have said, look, I wrote this letter months before we killed our parents, talking about this. That would have gone a long way to support what they were saying. Neither Eric nor Andy ever mentioned the existence of that letter in trial.
Okay, so maybe one of them forgot about it, but both of them forgetting about it, both of them forgetting that they had written this letter. And where's the original?
That's right, we don't know.
And so this is a photocopy. And a photocopy, you can't come in and age the ink, you can't identify the paper, you can't do anything to determine whether it was written at the time.
No, you can't authenticate it.
So there's no way to authenticate it. You got to have the original, which they didn't have. And they did testify about this. Does it materially add to what was presented at the time? And the lawyer for Eric at the time said, we're not taking a position that if there was sexual abuse, that it justifies the crime. She said, we're not taking a position now, nor will we ever.
Right, what she's saying is, and this is the law, sexual abuse, if it was true, is not a defense to murder. You can't just say, oh, I was sexually abused, I'm gonna go out and murder my abuser now. That is not the law. It does come up, and they did argue it as part of a imperfect self-defense, which is how the defense got to arguing for voluntary manslaughter, okay? It's not a real defense, it's imperfect, meaning that they had a good faith but unreasonable belief that they were going to be in imminent danger, that their parents might have killed them.
Right, but for real self-defense, you have to have a state of mind that you are in imminent danger, immediate danger. It's going to happen if you don't do something to stop it.
That's right, and other people, reasonable people, would agree with you. Hearing what your circumstances were, yeah, I agree, you were in danger. That's what self-defense is.
The father was shot in the back of the head, sitting in an easy chair, watching television, as was the mother. And these shotguns were purchased out of town under assumed names, and they offered 5 different stories at the time. Mafia hit. They went through all these different iterations of what had happened.
And I think that's what DA Hochman did such a good job of. He said, let's look this in the pattern of lies and deceit that they did from the very beginning, before the murders, all of the premeditation that they did, you know, going all the way down to San Diego and buying the guns with false IDs, planning out their alibis, planning out how they were going to stage the actual killing, what they did afterwards, how they tried to suborn perjury, and then these different versions that they gave. As you said, they started out saying it was a mafia hit. Then they tried to say that the father was a sexual predator and that he had raped one of Lyle's girlfriends. But the girlfriend said, I'm not going to testify to that. Then they said the father molested Eric, the mother molested Lyle. Then they changed it to both of them were molested by the father. And then the final thing they came up with was, well, they were so afraid that their parents were going to kill him, they had to kill him back. Because that's the only thing that they could actually come up with as a defense to murder. Because remember, they confessed all of this to their therapist. They said, we did it. So when you've already said, I did it, and I premeditated, you're going to have to find a good defense to be able to get away with it.
And you said that he was responding to the habeas petition.
Right.
But in a roundabout way was actually also addressing resentencing, because resentencing has to do with where they are now. Have they been rehabilitated? Would they be a threat to the community? And if this is not authentic, then it would suggest that they're still showing psychopathic behavior. They're still showing dishonest behavior. They're not stepping up and saying, look at our prison record, look at how we have behaved as prisoners, look at what we've done to better ourselves, to enrich those around us, et cetera, et cetera. Instead, they're saying to him, we're trying to manipulate the system now.
Right.
We had 5 stories before. This is story 6, which it seemed to me he was saying that doesn't suggest rehabilitation. That doesn't suggest accountability and owning the situation. That just seems like more attempts to manipulate the system.
Which I thought was fascinating, Dr. Phil, because everybody said, you know, the motion for new trial, that's hard to get. But this resentencing law in California, it's much more subjective for the judge to decide. Everybody has said, oh, well, they have been model prisoners in prison for the last almost 35 years, right? They've done all these wonderful things to help other people. They talked about how they've been bullied in prison, but they hadn't fought back. But the way the DA brought this letter up is implying that that could be a hoax. And if that's a hoax, and they are using that right now, that means that all this time that they say they've been rehabilitated and perfect, you know, people in prison, that puts a big hole in that. And I think that that's something that they may argue to the judge that, look, they may not have been rehabilitated because they're continuing on with the manipulation.
Why do you suppose if Gascon was sympathetic to their cause, he did not do this? He did not grant any of their motions, any of the things they were asking for on his way out the door?
So it's up to the judge still to grant these, but he could have put the resentencing hearing on the calendar before he left, right?
He could have, yes.
He filed a motion saying he wanted that, and he put his position out there. And I think Gascon wanted to raise the issue and let people know, hey, I'm sympathetic to them. I'd like to get them out for the people that are out there on social media, you know, pushing for that. But he even held back and didn't actually pull the trigger himself.
Yeah. So on the petition for clemency, which is directly to the governor of California, if he granted that, they could be released immediately.
Done.
They could be gone tomorrow.
Done. No hearing, no appeal, just you're done.
No evidence. It's just like it's his decision to say, I think you have paid your debt to society. I think that you've been rehabilitated for whatever reason. He makes a value judgment and says, you can walk.
Yeah.
Why do you suppose he hasn't done that? And before you answer that, we're going to take a break. People are going to have to stick around to hear what you have to say. So on the petition for clemency, which is directly to the governor of California, if he granted that, they could be released immediately. Why do you suppose he hasn't done that?
Hot potato. Hot potato. He was on a podcast last year and talked about this as well. And Ryan Murphy, he's the one who produced that documentary that got so much attention. He came and told me about this documentary. He said this is going to become big in social media and in the society. You might want to be aware of it. He said, I've been paying attention to it. And, you know, it's probably going to end up coming down to me in the long run. But he's holding back as well. And I just think there's mixed feelings about it. And now, especially with everything that DA Hochman has brought up, I think that's going to make people take pause and say, this really needs to be a thorough investigation here.
Well, I've talked to a lot of people about why they speculate that Gavin Newsom hasn't done something about this so far. And almost everyone, regardless of which side of the aisle they're on, have given the same answer. They say they believe he has presidential aspirations, and if he does make a run for president, that, you know, you are one that is turning murderers loose with no reason. You're overruling the courts, and that it's not the kind of political baggage that he wants.
Except for this resentencing. Gascon said he resentenced 300 people during his time in office. So we don't know yet how this new DA Hochman is feeling about the resentencing law on the books, but this will be a huge example of how he approaches it.
Well, I don't know. I read him as not being particularly likely, given what he considers to be disingenuous conduct surrounding the letter. And I think he ascribes to the theory you just don't reward bad behavior. So all of a sudden people start coming up with, oh, I forgot this letter that was an alibi or an explanation or a motivation or a justification. And so I'm going to come up with it not timely and present it. And I don't think that's a precedent he wants to set.
That was the read I took from him from the press conference. But remember, the resentencing comes down to the judge.
Yeah, but they do pay attention to what the DA recommends or doesn't recommend, and I don't think this is something he would be supportive of. So, well, this is certainly interesting. I just hope when people think about this, they remember what the crime was, how it began, and then also consider whether or not a price has been paid. Everybody will have to make up their own mind about that. Thanks for talking about this.
You bet.